If you read the invitation, you know that I have developed a continuing education class on how property managers are exposed to liability. It's a 4-hour course, and I have excerpted just a small bit for today that I think will be relevant. I hope it'll be interesting. I am now going to disappear and show you something. There we go. Now I'm off the hot seat. So the question is, when you're doing the business of property management, are you exposed to liability? And the answer is, well, yeah, you are. And the point of this material is to drill down into the various ways that we get ourselves exposed to liability, some obvious and some not. In order to keep this concise enough for today's meeting, I'm limiting the scope to the screening process, and specifically limiting the scope to 3 components of the screening process. We're going to talk about how we get exposed to liability through the fair housing requirements, through handling non-public information, and through handling requests for accommodations. So let's get started. Fair housing requirements come from a variety of sources. Most of us are familiar with the civil rights legislation at the federal level. There are also state statutory obligations. There are even local statutes and ordinances that govern fair housing. We also get governed by contractual obligations when it comes to fair housing. And we even have some industry obligations for fair housing. For example, I don't think you can be a member of MLS, and I know you can't be a realtor without taking an oath to follow fair housing requirements. So we have lots of things coming together requiring us to provide services without discriminating. And I'm going to focus just on the contract today because, it does a pretty good job of encapsulating everything. This is paragraph 6 from the association approved management agreement. We're not going to read it, but I have highlighted the fair housing language, and you'll notice that it's in all shouts. So they really want people to read this. They really want people to understand it. And it simply says that we're going to offer properties in compliance with all laws prohibiting discrimination based on these things that you're very familiar with. So every discussion like this begins with a recollection of these federally protected classes that we all know by the acronym Fresh Corn. I'm sure that you can reel these off like the lyrics to your favorite song: family, status, race, sex, handicap, color, religion, and national origin. These are the federally protected classes. And remember, I just went through a whole litany about there are other sources of fair housing requirements, state, local, and so on. So let me just start with a question. Do fair housing laws protect the LGBTQ community from discrimination? If you'd like to unmute and answer, I will give you extra points for being brave. If not, I'll answer the question if you just wait long enough.
Isn't that what the S is for? In Fresh Corn?
Great question. Sex does not mean sexual orientation at the federal level.
Include that. Oh.
It means gender. Yeah, there are a couple of these that could stand an update. We don't use the term handicapped very much anymore. And yet it's littered throughout these laws. So sex and handicap, gender and disability might be more current, politically correct ways to refer to that. Great question. Thank you, Eve. The LGBTQ community does not fall under the S, not at the federal level. So the answer to this question is no. The LGBTQ community is not protected at the federal level. At the state level, some states recognize the LGBTQ community as a protected class, some don't. North Carolina does not. At the local level, some localities, counties, cities recognize this as a protected class and some do not. And it is really a patchwork. I'm sure it's not beyond your imagination that Chapel Hill and Burlington, in counties that touch each other, might have different ordinances on this. In Chapel Hill, the LGBTQ community is a protected class. I don't know about Burlington. I just threw them out, throw Burlington under the bus, I guess. Next question. We know the penalty for violations is severe. We know that your exposure is significant. Oh, wait, sorry, I was reading my notes. Next question. A new landlord client hires you. This is a real world situation. I suspect some of you have had this happen. We certainly have. You get hired and the new client says, I want to conduct the showings, or I want to be present for showings, or I want to meet the applicants before I approve them. It's not really an unreasonable request. I mean, a lot of people, I'm a landlord too, and I would love to meet all my tenants before I approve them to get my own sense of whether I'm going to be able to work with these people, what kind of car do they drive, do they seem nutty to me, whatever. But as a property manager, how many reasons can you come up with to dissuade your landlord client from establishing a relationship with these applicants, certainly before they've signed a lease? It's a rhetorical question. I don't want you to list all the reasons. The opportunity for a landlord to discriminate in that situation and the inability of you to demonstrate that it wasn't discriminatory is just it's too great. The risk is too great. So what do? The only workaround that I know of for a landlord who insists on this is to say, it's your investment, it's your business, I get that. But for this to work that way, you're going to have to market it, you're going to have to show it, you're going to have to screen them, you're going to have to sign the lease, and then you can hire me. That's the only way to get you out of that. And if you can work with that, then you can try it. But absent that, I think the answer is, I'm sorry, the risk is too great. I'm not able to do that for you. Any questions about that?
I would only add, you can explain to them why. Say, hey,
of course.
And that's probably your best choice, is explain why they should not want to meet these prospects.
Yes, and that usually works. I'm sure that's
worked for us. I mean, that usually is, we explain why, and most of the time they get it.
Right. So we know the penalty for violations is severe. We know the exposure is significant. Most concerning is that we can expose our landlord to liability, and our landlord can expose us to liability. So how do you mitigate your exposure to liability, particularly in fair housing situations? Rhetorical question, just a thought provoker, because there are lots of ways. The simplest answer that I know to that question is to adopt policies and procedures that are legal, that are compliant. You must follow them consistently. If that consistency is a huge shield. And of course, you should pay your insurance premiums, because humans are humans. And in the best of situations and the best of intentions, things can still go wrong. Are we ready to move on to non-public information, or does anybody have any comments or questions about these fair housing exposures? Seeing none, let's talk about non-public information. Non-public information is the kind of information that you might have about another person that nefarious characters could use to the detriment of the person. So, you think about things like the Equifax hack, Home Depot, Marriott, Target, who hasn't been hacked? Facebook, who hasn't been hacked, and who hasn't had personal data get out of their hands? It seems to me that our best protection is being so small that no one would care. So, nevertheless, I mean, we have to think about the responsibilities and liabilities that we take on when we're handling non-personal information. The laws that impose those requirements vary widely, all different levels. The one that we're primarily concerned with is the Fair Credit Reporting Act. It's probably something you're familiar with. If you have ever issued an adverse action letter after screening a tenant, you have participated in the real world machinations of the Fair Credit Reporting Act. You have to notify somebody who's been declined where you got the information, so that they can challenge that if they've been perhaps the victims of identity theft. So what we're going to talk about today is how we get exposed to liability if we expose a client's personal information, whether by mishandling or by getting hacked ourselves. What is non-public information? This is the very, very minimum of what it takes to be handling non-public information on behalf of somebody else. It takes a first name or initial. So I'm T or Todd. It takes my last name, Crenshaw, and it takes one of these 6 things. Anyone will do. When I built this slide, I didn't think very much about it. I was doing lots of copying and pasting, and I built the slide and I put it all together, and I thought, well, that looks pretty effective to me. And then I got ready to present this material, and it occurred to me how many places we have our first name or initial, last name, and date of birth on completely public platforms, LinkedIn, Facebook. How many of us get congratulations, happy birthday messages from everywhere? So if that's all it takes for a nefarious actor to steal my identity, that makes me a little nervous. From a property manager's standpoint, it's not about what the nefarious actors can find and where, it's whether we can be held responsible for sharing that, mishandling that. Compare for a second what makes this, compare a transactional broker to a property manager for a second to chase out why this is so potentially problematic for property managers. It is conceivable to me that you could represent a buyer or a seller through the entire process and never touch any non-public information. That's conceivable. Things that would change that, if you work for a firm that requires you to take a copy of a driver's license before you go out on a showing, perhaps, well, that changes that. Now you're handling non-public information, and you're going to have to be aware of the exposure to liability for that. But, you know, absent something like that, I've certainly handled transactions where I never saw any loan documents. I never saw, I never saw anything that would put first name, last name, and any of these other things together. Now imagine a property manager trying to do his or her job like that. It is inconceivable to me that a property manager could do property management in an effective way without handling non-public information. So the question is, how can you limit your exposure to liability? You're gonna handle it. How can you handle it effectively? And again, this is a thought-provoking question. This isn't a yes or no question or a multiple choice question. I'll offer a couple of considerations. There's insurance out there. That's helpful. Insurance is insurance. You know, they'll deny a claim if they can. It's expensive. There are upsides and downsides, but you can insure against this. In our own company, we've adopted a couple of other things that don't cost us anything and we think are fairly helpful. One is to consider how our clients' and customers' data is stored, and we leave non-public information on other platforms, other vendors' platforms. What does that mean? Well, in the olden days, and I'm delighted to be old enough now to have olden days, in the olden days, when we used to request a driver's license or a pay stub or a W-2 or whatever, you know, they would email that to us, and then we would put that in their folder on our system, on our client drive, and that would be our data. When things got really dicey a few years ago with all these data breaches and so on, you know, one of the things that we changed was to stop doing that. So if you open a client folder on one of our drives now, you're not going to see driver's license, W-2s, things like that. Those sensitive pieces of information stay on other people's platforms like DocuSign. So if you get a W-2 from somebody through DocuSign, you know, you can see the you can see the social security number, and you have access to that. But if you leave that on DocuSign, DocuSign's responsible for the security of that information. We use PropertyWare as our management software. So when an applicant uploads information on an application into PropertyWare, we don't copy that down to our system. That stays in PropertyWare. It's PropertyWare's responsibility to keep that secure. Is it a King's X against liability? No. But is there a space between us and them? There's at least a little space. It's not been tested, but it's better than nothing. And it's free. I mentioned a moment ago that in the olden days, we used to email things like W-2s and copies of driver's license, paycheck stubs. We don't do that anymore. No more emailing. As soon as you transmit something like a copy of a W-2, or if you request that somebody emails you a copy of their W-2, your exposure to liability increases. This happens in the real world by people that you would expect to be far more sophisticated than, you know, me and my little small business. I just refinanced a home equity line a couple of weeks ago with an institution, a local institution with a great reputation, even a prestigious institution, I would say. And the loan processor that they assigned me sent me an email. I'm sure you've seen them. Dear Mr. Crenshaw, here's the list of documents that I need: W-2, tax return, paycheck stub, profit and loss. Send those over when you get a chance. What? What? By email? So I responded, thankfully, had the presence of mind not to just start attaching into a reply, had the presence of mind to say, hang on a minute. Do you have a secure portal where I can upload this directly into your system? Oh, yes. Here you go. Wow. It's so easy. It's so easy. One thing that might happen to you that I think is a little tricky is when you get an unsolicited piece of NPI via email. So a tenant or a landlord sends you something via email. You didn't ask for it. It's sensitive information. What do? Well, you certainly don't forward anything on or participate in the sharing of that. You can see it, you can get the information off of it that you need and leave it alone. You don't want to be in a position of being accused of requesting or handling information like that via email. Any questions about that? Very well. So let's talk briefly about accommodations. So accommodations is when somebody with a special need or disability asks for something different than another tenant without a disability might request. Let's examine this in a series of questions here, and imagine that you get an application for a property that the landlord has said no pets. I mean, I know this is happening to you, this happens to us all the time, no pets. But you get an application from somebody with an emotional support animal or a service animal. How do you manage compliance with the HUD regulations regarding emotional support animals while also honoring your client's directive that there not be any animals in the property? And I am going to encourage you to unmute and share your experiences, because I can't believe for one second that we don't have a variety of experiences in this meeting right now. How do you treat ESAs on a no pets property? That's the question.
Not a pet. So I personally don't like to tell the landlord, even though I know some of the brokers who work for me do, that there's a ESA. I personally would not, because it gives them an opportunity to discriminate, at least until after the lease has been signed.
I have a question.
Yes.
So if you chose not to tell the landlord, if the pet then produced any type of damage at the property, how would you explain that
It's
at
not a
the end of
pet
the lease?
to start there. It's an
Uh,
animal. So, but they are liable for the damage, regardless if it's an ESA or a pet.
Right. I'm just
Or
talking
an
about the
assistance animal,
pushback.
because there's also the assistance animal out there too. But that's less of a concern.
I guess I was just referring to the pushback that you might receive from a landlord more along the lines of, well, why didn't you tell me there was an animal in here?
Yep.
Yeah, and that's a judgment call. And again, I wouldn't. You don't want to. I don't think you should be telling them while they have an opportunity to discriminate. Maybe that's the best way to say it.
Okay.
So once the lease is signed, they moved in, then you can say, hey, by the way, they do have an ESA. I couldn't tell you because then you might have the opportunity to discriminate against them, and I was trying to protect you from that liability.
Okay. Makes sense.
Yeah, it's always messy because these ESAs are tricky.
Anyone else? Here are a couple of thoughts. I wasn't able to tell who was asking the question about discovering later that there was an animal in the house.
I think
You
that was
did.
Jade.
Okay. You may be able to avoid conflict about that if you frame the expectation, if you frame the landlord's expectations regarding fair housing and accommodations and everything else before you even start showing the property. Explain, I'm not going to tell you if I get an applicant with children. I'm not going to tell you the applicant's race. I'm not going to tell you, I can't tell you if they have an emotional support animal. I can't tell you if they have a service animal. And it's for your own good. You can spin that however you want, but you can't tell them. Then if you move somebody in who has an emotional support animal and it's found out later, and sometimes it's just a matter of, a former neighbor sending your landlord an email, hey, we love your tenants. My daughter has adopted their dog as her own. Wait, what, dog? Wait, what? It can be as innocent as that. It's happened to us. Or it usually isn't positive, that damn dog won't stop barking. Why did you let that tenant move into my house, driving all the neighbors crazy? And then the question is, wait, there's a dog there? If you frame the expectations and the answer is, yeah, there's a dog there because it's a service animal and I told you about this. Even better, frame the expectations, sign the lease, and then tell the landlord, by the way, remember when I told you about service animals? There's one on this lease. There's one involved in this lease. So then when he gets that neighbor's email, the landlord's already out in front of it. So managing those expectations can be enormously helpful. In terms of the way we think about service animals, and this gets to ESAs and service animals, this gets to Greg's point. It's very helpful to me to think of these critters as medical devices. So if you showed a property to somebody who was dragging an oxygen tank around, would you tell the landlord, by the way, this person's dragging an oxygen tank around? I might want to know that as a landlord, because I would expect that, my door molding is going to get banged into, and, the hoses getting dragged around corners might impact the paint. There are lots of reasons why an oxygen tank, and the house could blow up. There are lots of reasons why an oxygen tank might not be especially desirable, but you would never tell your landlord that, this person has a disability that requires them to drag an oxygen tank around. Well, what if on the end of that hose or that leash is a dog instead of an oxygen tank, or a pig? It just seems to keep things more clear if you look at those animals as medical devices, and manage the information about them accordingly. Anything more about any other comments, questions about the liability we take on when we deal with ESAs and service animals as requests for accommodations? All right, seeing none.
Yes, sorry.
Yes.
Hi, do you differentiate between service animals and emotional support animals.
In terms of how we manage that information with our landlord clients, no. In terms of how we process applicants, there are some differences. This has to do with whether, it's an ESA under HUD or a service animal under the ADA. And that gets into things like, well, is the disability obvious? Can you request documentation? Is that where you're headed with your question?
I had tenants who brought in the fake internet, sorry, I assume it was fake internet certifications for their animals. And each one of them happened to have an emotional support animal.
Yeah.
So I want to see, I know Eve's on the call and they use a service to vet the service animals. And so I wanted to see if there's a way to clarify that it's a legitimate agency that's certifying the dogs or animals. And so we don't have to get into the mire of it, the liability of asking about disabilities, but we can guarantee that it's a legitimate need.
Guarantee is a strong word.
Sure.
I'm feeling you. And Eve, are you using pet screening? You can just nod, I can see you. Okay, so we adopted that platform recently as well. Those of you who aren't familiar with it, it's not perfect. They don't handle it the way I would if I owned their company, but it's an opportunity to outsource some of this responsibility to a third-party vendor and take some of the pressure off our brokers. Because again, we're talking about managing liability. We're talking about non-lawyers who get some training like this on how to handle these issues, having conversations in real time, maybe being asked questions that put them back on their heels, trying to come up with an answer that's not going to get them sued, out there standing in the hot sun. So we adopted the petscreening.com platform so that our applicants go through, it's kind of like the application process takes a little hook. If they have an animal, they go through a little animal hook, then they come back to the application process. And pet screening is supposed to be looking at things like their emotional support animal certification and determining, making a recommendation whether to grant the accommodation. I haven't been using it very long because for a long time it just wasn't it wasn't compatible with our systems and it was going to create more work than we thought it was worth. They recently reached an agreement with Propertyware to integrate, and so that made it possible for us to now start using it. Eve, have you been using it for long, and do you have any feedback on that particular service?
Yeah, we've been using it for a while now. I don't remember the exact date, I'll be quite frank. But I would love it if it worked, if it integrated with Appfolio, because it is something we have to kind of check up on because it's tenant based, which is great, right? That each tenant has to certify or agree that they don't have an animal or a pet or whatever. I actually just pulled up their website because you can correct me if I'm wrong, but I believe that the online certificates now, we don't have to accept those. Before it was like a little hazy because you had to kind of figure out if it was hard to figure out if they were legitimate or not. But I think that there was an update recently. We were just in a fair housing class or thing recently. I thought that they made some update about the online certificates and that you could be a little bit more critical of those. And pet screening actually indicates that they reach out to the medical provider that I guess that's indicated by the tenant or noted by the tenant. So we found it to be quite nice, kind of helps us review the information that we need to decide if the pet or the animal can be in the property or if there will be a pet or animal in the property.
Thank you. I appreciate that. And this is not a emotional support animal service animal presentation. And so I think I'm going to steer us back to other issues of liability, and encourage you, let me know if you want contact information about petscreening.com, or just go to petscreening.com. You don't need me to type that out for you. And take a look if you're interested. I'm not aware of any other vendors who are competing with them at this time. Or you can continue doing this the old-fashioned way and educate yourself under the HUD and ADA requirements and deal with those certificates on your own. I'm going to move on to a different accommodation request. And ask the question whether, what do you do when an approved applicant says, I love the house, I'm going to lease the house, all the terms are fine, except I need permission to build a ramp to the front door? What's the right way to handle that request? The real question is, do you tell the homeowner, do you tell the landlord, this applicant needs permission to build a ramp?
Wouldn't you have to, I mean, I know it's a reasonable accommodation, but wouldn't you just have to disclose that to the landlord and let them know, hey, this is a reasonable accommodation?
That's the question. And the follow-up question is, are you giving your landlord an opportunity to discriminate? So let me make this a little bit more challenging, and we'll suppose for the sake of, oh, my vocabulary is failing me. For the sake of hypotheticals, you have two applicants who appear equal in all ways, except one needs permission to build a ramp. Do you present them both to your landlord and tell the landlord that this one applicant needs permission to build a ramp?
And we're assuming that that one applicant has an apparent disability that would require
Yeah,
a ramp.
yeah. The legitimacy of their request is not in dispute. They need a ramp.
Okay, can I try to answer?
Yes, please.
You present them both, but you don't tell them about the ramp until they are under a lease.
Okay. So I think that is the right answer. I don't think that you can tell your client that the applicant that you just screened, who is a qualified applicant, is going to have to build a ramp without exposing yourself to some liability. And remember, that's what this is about: managing the exposure, managing the exposure. If I were handling this applicant, I would use my power as the agent to negotiate the terms of the lease and include provisions like, you have permission to build a ramp. You also are required to return the property to its original condition at the end of the lease. I would investigate whether I could charge an additional security deposit or charge some sort of restoration fee in advance, the way we can charge a cleaning fee in advance.
You can't, by the way, just FYI.
I thought we could collect a cleaning fee.
The cleaning fee, yes, but not for like a ramp removal.
Okay, because it's a disability request.
Correct. So just FYI, you can't do that.
So figure out how you're going to negotiate the lease on behalf of the landlord, so that when you present this lease to the landlord and say, by the way, they're going to build a ramp and I gave them permission, here's why, and here's what I did to protect your interests as well as I could. That's how I would handle it. Criticisms, feedback, alternatives. I have another question coming up that's very similar, so you're going to get another opportunity. Next question, same applicant, except this time the applicant says, love the house, I'm fine with the lease terms, but I want one thing. I want the landlord to build me a ramp. How do you handle that request?
assuming we're not talking about multifamily, because apartments have a different regulations than we do, and then single family or townhouses, things like that. I think now you take it to the landlord because they're requesting the landlord to pay for it. The landlord's not required to pay for it under the reasonable accommodation rules. That would be my guess.
That was my expectation as well. I think that this is lease negotiations. If you're being told to present this to your landlord, then you are not liable or not likely to be liable for sharing that information with your landlord. If your landlord uses this information to discriminate against an applicant, you know, I think it was the applicant's decision for the landlord to have this information and not yours. Is it perfect? Nothing's perfect. Is it better than not? Yeah, it's better than not. Any comments, any challenges, any feedback? There's one thing I want to go back to. I'm going to go back to where, I apologize. I want to go back to this no pets property, and I want to make it just a little bit harder. If your landlord client, this is another real world situation. If your landlord client says this is a no pets property because I am deathly allergic to pet dander, I'm going to Barcelona for a fellowship for 2 years, and then I'm moving back into my house, it absolutely has to be animal free, or it will be a health problem for me. And then you get an application with a service animal. Any thoughts?
That's the call your lawyer example.
Can anybody do any better than lawyering up?
Yeah, I mean, I can come up with an answer, but that's because, well, but I'd like to hear someone else answer.
So I think the
You still can't restrict a service animal. I mean, you still can't say no to a service animal.
I think that's correct.
Yeah. You can offer them cleaning suggestions, HVAC cleaning company, you know, get everything wiped down.
Well, then the question is, whose disability trumps? Whose disability wins? Yeah, and again, that's why I said that's time to lawyer up, because now you're going to go into the deep dive. Because I don't want anyone to say yes, you can discriminate, just say no. But I would definitely go look. I would definitely do the deep dive into the case law and see what the courts have said.
But it would be interesting because if it's the owner's allergy, disability, or whatever, they're making that decision to put this house out there.
True. I mean, there's a lot good arguments both sides on that.
Yeah. Anyway, that's an interesting. Yeah.
That's actually happened. It is thorny. I believe the one time I remember this happening, it was resolved by having an honest, open conversation with the applicants and explaining, you know, why the owner is making this a no pets property. And I believe in that one case, they were sensitive to that. But if they hadn't been, I don't know what would have happened. You know, so I guess the answer to this question, there is no answer. The answer to this question is, you know, how do you process the requests? And as in most cases, I think the right first step is to just be open and honest with the people you're dealing with, and I hope that more times than not, people will be reasonable. It's those cases when people are unreasonable that keep us up at night, and it's those cases that make people like me design courses like this. So yay. That's all I have today for liability in the arena of screening, though, in those three spaces. Does anybody have any questions, any comments?
Thank
I
you,
want
Todd.
to go ahead.
Thank you, Todd.
Oh, you're very welcome. I do want to encourage people to use the Google group. If we hang up off this call and you're like, wait a second, he said, pop it up in the Google group, and we'll deal with that. You can always contact me directly as well. But that's what we have for today. I hope that was informative and enjoyable. Cub, anything from the association?
No, sir, we're all good. Thank you.
Yes, my pleasure. Greg, anything from the co-chair?
Nope.
Okay, thank you, Cub, so much for doing this. Such a valuable partner. Thank you all for attending, and I'll see you next quarter, if not before. Have a great day.
Thank you.
Thank you, Todd.